I'll start. First of all, I'm going to give you a little update. On the last session, we spoke about all of the sanctions. Now, since then, the Department of Justice created a body called the Klepto Capture Task Force. So they are working with the Department of Treasury Department. So the sanctions, while we examine the ones that the Treasury Department controls and runs, since we met, the Department of Justice has formed a group. It's being headed by a woman named Lisa Monaco, and she is going to be running the whole thing in cooperation with Treasury. Their main duty is identifying oligarchs who hold property in the United States and seizing all of their assets. So this is a new step. It's a little bit more legal. I'm assuming they're going to have the opportunity, if you're an oligarch, to contest this and file in federal court. But it is going to be working under both civil and criminal forfeiture laws to seize all of these assets. One other thing that I didn't mention last time is that there is a list of sanctions against, it started out as the Navalny 9, so 9 individuals who were identified in the poisoning, arrest, all of this with Alexei Navalny, but now it has expanded to the Navalny 35. So this is a longer list of people who cannot, do business in US dollars, whose assets would be frozen here, and cannot come into the United States. And since all of this started in Ukraine, the US has published a list of oligarchs that they're focused on. That's available here on the Department of Justice, Department of Treasury's website. But I can send a link to Victor, and he can maybe, like, if you don't have access to that, screenshot it and post it for you somewhere. So today we're going to be discussing what makes a fair trial. What are the requirements under international law? And I'm not talking just trial. I'm talking everything from investigation, arrest, so pre-trial, all the way to the sentencing. These are, I'm going to switch to PowerPoint for the rest of this. And you'll be able to follow along the laws that make this. And of course, we know in Russia, watching the Navalny case and what's going on with 15 years of arrest if you, say something untrue, that you're going to be looking at it from a perspective of your country. But you also need to know that these are really the highest standards. I have worked in US courts, and I have seen in US courts where these standards have been violated. One example I'm going to give while we work through this is the right to have an interpreter, to have all of your trial be interpreted and from beginning to end. And I worked on one case where the person who was indicted was Liberian. And Liberia is a country in Africa that was founded by the US for its slaves. And they speak a language that's very similar to English. It is English, but the words mean different things. And in the middle of the trial, the judge, and in the United States, to be a federal court judge is a lifetime appointment. So our judge was 80 years old. She decided that the language sounded so similar to English that she got rid of the interpreter. So this is a violation, as you're going to see, of a fair trial. Another thing that's very common in the US is you're oftentimes, especially in federal court, not allowed to bring in a laptop or a telephone. So if somebody is monitoring a trial, it's almost impossible. They're just scribbling notes. So I worked for a group in Geneva that was monitoring trials in the US of war criminals, and our monitors were having to sit and, scribble for notebook after notebook to take notes of what was happening. So we'll see now that this idea of a fair trial is really the ideal. And it's not usually, every country has to strive for that. I don't think any country really gives 100% all of the rights, but this is something I'm very, very, very passionate about. You need to know that the United Nations, Open Society, Justice Initiative, the Open Society that's funded by Soros, they've all eliminated their court monitoring programs. And I think this is an enormous tragedy. And as much as you are monitoring trials in Russia, I am happy to work with you individually in setting up monitoring programs, in setting up trials. I work with a group that uses technology for human rights. It's called EOS Tech Trust, and I'm happy to work with you. We're trying to create an app that will allow it to be very simple to monitor a trial. So all of the things that we're going to talk about today, you'll be able to follow on a telephone. And as you're watching, you'll be able to put in information. And at the end, that information can be sent somewhere to, for example, a law firm in London and New York that can just determine, is this a fair trial? And keep a collection of documents to see how a certain country is dealing with their trials and their court and sentencing and jail and everything. So it will be able to monitor all of that. So if anybody after this today wants to talk to me, please do, because I'm very, really, really very passionate, because unless you have this as a basic, then the human rights of all people in your country are never going to be, nobody can be guaranteed a fair trial. Okay, so we're going to start. I'm going to share my screen. First, let me open my PowerPoint. There we go. We're going to look first at the documents that are the basis of a fair trial. The first is the United Nations Declaration of Human Rights, the International Covenant on Civil and Political Rights. That's probably the most important document, which sets out what you need to have a fair legal process. The Geneva Convention, and that's dealing with trials during conflict. This doesn't apply to you, the African Charter on Human and People's Rights, and of course the European Convention on Human Rights. So there are three main goals of trial monitoring: to evaluate the fairness of a trial by providing an impartial, independent, and comprehensive report of what transpired. So if you're monitoring, you need to see, is this trial fair? And we're going to get into what makes a trial fair. The second point of monitoring a trial is to advance human rights protection by putting the trial participants, including the particular judge and prosecutor, on notice that they are under scrutiny, to act as a diagnostic tool that can help identify reforms in the criminal justice system of that country. So as I'm saying, if you have a telephone app or a laptop app that's able to monitor everything, at the end of the year, you will see that every trial in Russia, every trial in Sweden, wherever, is what's going wrong or what's progressing correctly. There'll be a data collection of all of the court monitoring. Okay, so the rights that must be guaranteed in order for there to be a fair trial. The first right, this is before trial even begins, the right to be informed of charges. If a defendant is not aware of the charges against them, they won't be able to prepare for trial, and they'll be at a significant disadvantage. So International Covenant on Civil and Political Rights, Article 14 says, in the determination of any criminal charge against him, everyone shall be entitled to the following minimum guarantees: to be informed promptly and in detail in a language which he understands of the nature and the cause of the charge against him. Usually this means a written, for example, if you were in the United States, you'd have to be served and you'd have to have a written indictment delivered to you. The defendant's right to be informed of the charges against them is a key to ensuring the proceedings are fair. The reason is simple. The defendant has to be able to mount an effective defense only if they know what they're accused of having done. This right is closely related to the right to have adequate time and facilities to prepare for a defense, as a defendant needs both the requisite information, time to act on it in order to defend themselves effectively. If you're monitoring a trial or pre-trial, you must document when and how an individual is informed of the charges and how the authorities or prosecution address changes to the charges. So indictments can be amended. You can be indicted for XYZ, but in the course of the investigation, they find that you did B, that you did something else. So that can be added to the indictment. In the same way as the original indictment, you have to be informed, and you have to get a notice of that way before trial begins. As soon as a person is formally charged with a criminal offense, or the person is publicly named as an accused, they must be informed promptly and in detail. They have to know the charge. They have to know it in their own language. So you need to find out as a monitor, when was the defendant informed of the charge and in what manner, So he can't just be arrested, put in jail, thrown in front of a court, and not have with it before in his own language what he's a list of what he has done, what he's accused of having done. They need to know this in advance, enough to prepare for a trial. So this should be months in advance of a trial date. It's important as a monitor to check how much detail was provided, when were they notified of the charges, and what language was used. Also be sure to note whether the charges against the defendant were changed. So they need to have time, as I mentioned, to react. What to watch for. A defendant can mount an effective defense only if they know what they're accused of having done. It's closely related to having time and facilities, as I mentioned, and they have to know, and they have to be tried on the charges of which they've previously been informed. You cannot bring somebody to court and then throw in new charges as the trial is proceeding. This has to all be done before. What do you watch for? Unless there are good reasons, I think I put this in the PowerPoint. Unless there are good reasons for delaying a notification, the defendant should be informed of the charges within a couple hours or days before his arrest. Notifications of charges must be provided in writing. The defendant must also be informed of the charges sufficiently in advance of trial. The defendant also has the right to be tried only for the charges that he's been notified of. They must be given sufficient detail regarding both the alleged facts and the legal characterization of those facts. So they have to be told not just he robbed a bank, he stole bread. You need to put exactly, the prosecutor needs to have exactly which rule for in the United States. If it's a federal prosecutor, he'd have to put exactly what federal law section, division of that law this person has violated. And finally, authorities may sometimes amend the charges, as I said, but only if the defendant still has sufficient time to react to amended charges. The worst instance of this I saw was in the international courts, because international courts are able to indict people on one crime, and then since they're held in prison for so long, and I'll use the example of Slobodan Milosevic, he's held in prison for such a long time that they, while he's in prison, are working and building his case. That shouldn't be happening in a national court. But that does happen. So again, this is an ideal, that you are tried for one thing, that you are aware of what you're being prosecuted, and only in advance of your trial that your indictment is amended. The right to adequate time and facilities to prepare defense. This enables the defendant to test the prosecutor's case. They have to have time for their own defense lawyers and their own investigators, if they have them, to look into the charges, to examine the facts, to start preparing materials, documents, witnesses, calling and organizing their own case. It enables the defendant to test the prosecutor's case. If the defendant isn't able to prepare, the prosecution will enjoy an unfair advantage, increasing the risk of an unfair trial. As the UN Human Rights Committee put it, the right to adequate time and facilities to prepare a defense is an important element of the guarantee of the fair trial and application of the principle of equality of arms. Again, the International Covenant for Civil and Political Rights is the most important document. Article 14 says, in the determination of any criminal charges against him, everyone shall be entitled to the following minimum guarantees: to have adequate time and facilities for the preparation of a defense, and to communicate with counsel of his own choosing. Every defendant has a right, and we're going to get this, is going to be the next one, to choose their own lawyer. If they can't afford one, the state should provide a strong public defender. And this varies in every country. For example, in the United States, we have every prosecution's office has a matching state public defender and a federal public defender. I know in the United Kingdom, they actually have, I don't know if this is better, but you're able to call on top private lawyers who are paid at their private rate to defend someone. So if, for example, I am accused of a rape, I will find the top lawyer in a private law firm, and the state is then obligated to pay for his, if he's available, to pay for his fees. If the defense isn't able to prepare, it really will lead to increased risk of an unfair trial. And if you're monitoring a trial, you have to note how much time has passed between the moment he was first indicted, received his indictment, when he was first questioned as a suspect. So if he's brought in, not indicted, but is held as a suspect for a month and question, that is a clear indication. There has to be time for him to say, stop, I need to call my lawyer. I need to be able to address these charges with my lawyer. This should include, they have to have time to pull all the key materials for the case. And this should include all materials that the prosecution planned to use in court. So if the prosecution already has a list of witnesses, if the prosecution already has a list of exhibits, that must be made available to the defendant, because the defendant has to have time to be able to challenge what is going to be used against him. They also have to be what also has to be made available to them is it's called in English exculpatory evidence. So if the prosecutor has evidence that in fact they have a photograph of, maybe he was driving too fast, they have a photograph of his car going through a speeding thing at the time that he's being accused of whatever he's being accused of, and that he couldn't have been there, that has to be handed over. Anything that works against the prosecution case has to be handed to the defense. What I've seen in the US in federal courts is very high standard, because they are held to a very high standard. And if they're found to be holding exculpatory evidence, it could blow up their case. There'll be a mistrial, and they'll lose the case if it comes out that they've hidden exculpatory materials. Having worked in the international courts, it's not such a great standard. I've seen prosecutors knowingly sort of either say, oops, we never realized we had that after the trial, or sliding it in with other materials so that the defense might not be aware. So it's very, prosecutors don't like, I mean, it goes against what they're trying to do to hand over exculpatory evidence, but they have a legal obligation under international law, under international standards, to do that. So you have to inquire about the time between when he was first questioned, when he was first indicted, between the time when he first gets his file, You cannot have somebody getting their case file that's being filed, that's going to be used against them in court the day of their trial, or a week before their trial. They have to have time to prepare. So you're going to have to be gathering, if you're working with somebody who's been held, you're going to have to be really gathering details, and perhaps making even a timeline for yourself to say, okay, this is when my guy was first named as suspect. This is when he got his materials. All of this, because these are all indicators that the less time there is between these factors and the trial, are indicators that the trial could be unfair. So how do you evaluate whether the time is fair or not? Some things are obvious. Like I said, if the case file is given the day of the trial or a day before the trial, obviously it's unfair. But you're also going to be putting in the perspective of how serious are the charges. If your client has been charged with very, very serious, for example, like the Milosevic case, or somebody who's been tried with, bombing a building. These are very serious charges that are going to be very detailed, and the case file is going to be very large. Person will need months to prepare. So if it's more serious the case, the longer time that's needed for preparation. If it's a minor theft, an accident, car accident, something like that, that's one small isolated incident, you won't need as much time. So it's up to you monitoring to figure out, and to put that into your perspective of how much time the client needs. You're also going to want to know, what is his or her lawyer doing? Are they reacting? Are they reviewing the materials? Are they asking for an adjournment or postponement? So if the person receives the materials very close to trial, it's the lawyer's duty to say, this is unfair, and I'm going to ask for a postponement for 2 months or 3 months, seeing how much the material, how many boxes of evidence are being brought over. You're going to need, that lawyer is going to need to put that, file something in front of the court to ask for more time. You'll also want to determine if any fees or procedural obstacles were imposed that hindered his access to his own file. Were there limits on access, such as rules requiring the defendant to only inspect the file at the prosecutor's office? Is he only allowed to expect, him or his lawyer, to inspect the file for a short period of time? In the United States, it's really a matter of delivering materials. Everything has to be photocopied and sent to the defendant or to his defense lawyer. You will also want to identify whether the defendant has access to experts who might be necessary to assist him in his defense. If he's being charged with something, some sort of shooting, for example, you'll want to get a person who's an expert on, saying that he couldn't have shot at this range or that range. It's essential that that defendant has a right to find somebody and has the time period to find and speak with an expert. If there were restrictions on his access to evidence, so he wasn't allowed to get a box of his own materials photocopied and sent to him, you should find out, was there a reason given by the prosecution, such as national security? So, for example, in the United States, in terrorism cases, there's a whole court that just deals with that. Those people oftentimes are not given their full file. For security reasons, for national security reasons, and that can be an excuse. In the U.S., it's this big excuse of terrorism that has been used in a lot of times to limit an individual's right. But you may get a document where, for example, a witness is named and it is so heavily redacted, meaning the document is blacked out on so many facts and so many names that a defense, it's not even possible for him to know who he should be speaking to, or what little elements of that person's testimony could hurt him. And that is a challenge. And in the United States, it's terrorism. That's where rights go out the window to follow some of these rules. And we have specific courts in DC that deal with this, that are completely closed, and nobody is given access to this information. And of course, like Guantanamo. So every country is struggling with this issue of national security, but it can be used in a sweeping way, which really limits not just the defendant's rights, but also his human rights to actually defend himself. Other factors to look at in order for fair preparation of trial: could he communicate with his lawyer in private? If all his calls are being monitored, if his visits are being monitored, that's not a fair preparation. He has to be privately able to speak to his lawyer. How often could he meet his lawyer, and for how long? That's also an indicator if he's properly allowed to prepare for his defense. If security guards are listening, or if it's being filmed, those are all limits on a fair preparation, because you don't know who is, using that. Is the prosecution seeing all of this? Then in trial, were there any physical barriers to communications, such as, was the defendant physically away from his defense lawyer? Was he held in a cage? Was he put in a glass area that he's separate from his defense lawyer? In the United States, it's always been essential that the defense lawyer sits right next to his defendant, because they're passing notes. And when, for example, the prosecutor is questioning a witness, the defendant has a right to be sitting next to his defense lawyer and saying, no, actually, this and this and this is what happened, because the defense lawyer will have to cross-examine. And he'll have to be prepared. And he can only really do that if his defendant is close to him and they can communicate. So this right has two main areas of focus: the right to have adequate time to prepare a defense, and the right to have adequate facilities, meaning the ability to access relevant documents and other evidence. So it's a two-pronged test: the time that he has, and can he meet with his lawyer? Can he look at the documents before he has to be in trial? The right covers accused persons, but some human rights bodies have indicated that suspects, persons who are detained, or those who are otherwise substantially affected as a result of an investigation against them, may also have this right, at least in part. For example, if an accused person may enjoy a right to access essential documents in the case file, the right applies at every single stage of the proceedings. It means adequate time to prepare for defense from the running of the moment a person is informed of their charges. So from that moment, he should be able to communicate with a lawyer and know in advance that he has time to prepare before ever going before a judge. They should also be informed of changes in the indictment, changes in the case file, new witnesses being called against them. They should reasonably feel that if they reasonably feel that they do not have time to prepare, they should request an adjournment, which means stop the trial, or a postponement. So his lawyer should immediately, when he's sensing this, get involved and slow things down. What are factors that you should look at? Again, how complex and what is the nature of this case? Of course, more time is needed the more complex the case is. Number of counts and charges. If you have a long list of charges that the person is charged with, it's of course, and they violated 10 laws or 12 laws, it's of course there should of course be a longer period for them to sit with their defense lawyer, prepare their case. The gravity of the charges. How serious are these charges? The more serious the charges, perhaps if they're going to result in death penalty or life sentence, then you really need an adequate time to prepare your defense. The status and scale of the prosecution's disclosure. Like I said, some cases, it's boxes and boxes and boxes of material. You cannot say to a defense lawyer or a public defender, or even if the client is defending himself, you cannot say you have a number of days. You have to give that person a number of months to review all the material in those boxes. And the stage of the proceedings. You need to think of at what point is new material being introduced. If suddenly there's a flood of new witnesses being introduced, you will have to ask for an adjournment, a pause, a stop in the trial so that you can look at these new materials or witnesses. So what are the keys to look at for facilities? It doesn't mean that the defense and prosecution have to have exactly the same access to materials or experts, but it means that they have to have a fair right and fair time to prepare their materials and get access to their witnesses. The UN rule on due time is it is the duty of the competent authorities to ensure lawyers access to appropriate information, files, and documents in their possession or control in sufficient time to enable lawyers to provide effective legal assistance to their clients. Again, as somebody if you're working with defendants, you're going to have to be the judge of that. And again, there's so many factors. How many defense lawyers does this guy have? How many boxes of evidence? All of this has a subjective element, but it should be reaching a standard that is the United Nations standard of what guarantees a fair amount of time and facilities to prepare for a defense. One example that the UN Human Rights Committee addressed was a defendant who was accused of crimes punishable by death and was allocated only 4 or 5 hours to familiarize himself with each of the 19 volumes of case files. So the UN Human Rights Committee said it was a blatant violation of his human right and his right to have a fair trial. It should also be free of charge. The prosecution cannot start charging the defense for, we will bring over 6 binders if you pay us 600 euros. It has to be completely, it's part of the process that has to be all handed over free of charge. So the limits, as I mentioned, national security. The other limit is to preserve others' fundamental rights. As I mentioned, if you have, in terms of a terrorism case, somebody witness who's testifying, you may not want to reveal who that is. If it's other sort of violent crimes, you may want to protect witnesses' names. So that would limit all of the information that the individual is getting. And there's also an attempt, for example, rather than just handing over witnesses, and this has been in the United States in gang cases, in sort of mafia cases, where you're limiting the names and things because you don't want the individual to be tampering with that witness or threatening that witness before a trial. And when the prosecutor gets something under confidentiality, again, the prosecutor will have a duty to protect that under confidentiality. And the witness will be limited in perhaps for the security of the country, or an individual be limited in what they can hand over. The reasons for this are: it enables the defendant to test the prosecution's case, and if he can't prepare in time, the prosecution enjoys an unfair advantage. If evidence is withheld, there should be an counterbalancing. That's something else to keep in mind. So if one witness can't be identified, hopefully there are, for that one charge, hopefully there are other witnesses who can be identified for that charge so that the defense can address it. If it is redacted and the names are taken out, there should be summaries of that information of what is going to be presented in court and what the defense, what the prosecution is going to be um, introducing. There should be an attempt to stipulate the facts. So as much as the prosecution can, their prosecution should state these are the facts. Does the defense agree to these so that they don't have to contest them in court and waste their time? And if necessary, you can have judges involved in examining statements that are redacted without the redaction. So you can have a judge reviewing that. And for example, if the named person is somebody extremely unreliable or there's problems with him, the judge would be notified of that in an ideal situation, and he could come in as the person who's able to review everything without any sort of redaction or removal of information. Due time means the defendant must be able effectively to prepare their case and access to relevant documents to the latest submission of merits of the accusation to the judgment of a court. So in a case that went before the Inter-American Court of Human Rights, which as you have the European Court of Human Rights, you have in Latin America, the Inter-American Court of Human Rights. There was a case called Castillo-Petruzzi versus Peru. It found a violation of the defendant's rights where the case file was only made available to the defense one day before delivery to the judge. So again, it's always going to be this. It's always going to be how far ahead can they prepare? How far ahead can they get? Not giving your client a case file or giving it a day, or in my opinion, a week or a month ahead for serious charges is denying that individual of human right of a fair trial. So these are the indicators that you're going to look at. I've mentioned these already. So these are questioning of a suspect, but the time period between being questioned as a suspect and the case going, how much material is in the case file, time between him getting the case file and the start of trial, any requests for adjournment. All of these slides I'm sending to Victor, and he'll be able to translate. And so you'll have this as if you're monitoring or you're working. All of these slides that I'm presenting for you are summaries from international law. So this isn't just my mind inventing what's a fair trial. These are the international legal standards. Whether the defendant had access to experts before the trial, and his ability to communicate with his counsel. Now, our third right that we're looking at is the right to counsel. Counsel meaning a lawyer. The right to counsel plays a critical role in the fairness of a trial. In cases involving possible imprisonment or even capital punishment, it's particularly important that the defendant be effectively assisted by a lawyer at all stages of the proceedings. So in an ideal situation, the moment somebody's called in as a suspect, they should have an attorney with them. In many cases, defendants are unaware of the intricacies of the law and may not be able to present an effective defense without help. Fundamentally, the right to counsel is about equality between the prosecution and the defense and reducing the risk of a wrongful conviction. Article 6 of the European Convention of Human Rights says, in the determination of any criminal charge against him, everyone shall be entitled to the following minimum: to be tried in his presence and to be tried in the presence and be defend himself in person or through legal assistance of his own choosing, to be informed, if he does not have legal assistance, of this right, and to have legal assistance assigned to him in any case where the interests of justice so require, and without payment by him in any such case if he does not have sufficient means to pay for him. To have adequate time and facilities to prepare and to communicate with his counsel. So it is US law, the moment somebody's arrested, they're informed of their right to have an attorney. They have to be provided an attorney whether they can pay for it or not. As I said, in the US, we have both state, if it's state charges, if you're being charged by your state, if you're being charged by your federal level, you have two levels of public defenders who are available: state public defenders and federal public defenders. Federal public defenders are exceptional in the United States. Um, in one of the cases that I worked on with Liberians, they were being defended. They were being defended by federal defenders. Federal defender did a million times better job than a private lawyer that was provided in the first case. So there has to be an ability to get a lawyer without paying for that lawyer. Those accused or suspected in criminal cases have the right from the time of arrest or detention, or from when they're first questioned by the authorities. So as soon as possible, if you're monitoring, the sooner that an individual gets counsel, the more likely that trial can be judged as being fair. So some countries, some jurisdictions do permit temporary denial of access, but the UN Human Rights Committee has expressed concern about any laws that permit delays in access to a lawyer for up to 48 hours. And the UN Human Rights Council and Human Rights Committee have both called for immediate access to a lawyer to be the standard. It plays a critical role in the fairness of a trial. And the most serious, again, is if it's any trial that can result in a life sentence or capital punishment, so death sentence. In those cases, it's absolutely 100%, if they don't have right to counsel, a violation of their human right. It is possible in some cases, if a defendant believes he can defend himself, to be allowed to defend himself. Most people are aware that's not the best thing to do ever, even if you're a lawyer, to defend yourself. But this is under the legal standards allowed. So in most instances, the standard is they have a right to choose. So if the individual is choosing to defend himself, that is his choice. He might be impeding his results and his the fairness of his trial, but he has that right, and he also has a right to choose his counsel. I saw individuals in front of the Yugoslav tribunal pick some of the worst lawyers I've ever seen and pay them lots of money. So that's the individual's right, but he's exercising that right, and as long as he's exercising that right, he is going to be there's not going to be that question of is it fair or not. It's only when he's denied that right. So if you're monitoring, you should be recording whether the defendant was represented by counsel. If he's not, you should find out whether he chose not to be. You should also find out when he obtained legal representation. Again, if he's given a lawyer the day before trial, that is clearly not going to result in a fair trial or fair representation. So it's important to speak with the defendant and find out when he obtained his counsel, when he was offered his counsel, and what happened before he had counsel. So if he went through the whole process of being questioned, detained, having charges filed against him without counsel, that should raise a red flag for you right away that his right has been violated. Another element to this is they should have the right to be informed. So if you have somebody who maybe doesn't know, who's completely outside of this legal sphere, doesn't know he has a right to call a lawyer, that whoever's investigating him, under the US Constitution, he has to be informed right away by that investigator. You have a right to remain silent, to call a lawyer. All of these are guaranteed rights, and they protect the individual. If the individual is not informed and is held and goes all the way, perhaps even through trial, not knowing he has that right, his human right for a fair trial has been denied. So yes, the right to counsel plays a critical role in the fairness of a trial. especially again where it's imprisonment, life imprisonment or capital punishment. It's essential that they're being assisted by a lawyer who's able to handle the case and from the start of the proceedings. So, in terms of how a defendant is informed about their right to have access to a lawyer, the European Union's directive on the rights of access to a lawyer states that information may be provided orally or in writing, but that it must be given in simple and understandable language. So, for example, if he's when he's receiving his indictment, or when he's being arrested, if his indictment says at some point that he can challenge this, then that standard has been met. As long as he at some point, either orally or by writing, has been informed he has a right to a lawyer, his right to being informed and get access has been met. So it is possible, in very rare circumstances, for the state or the court to step in and say, this lawyer has to be removed. For example, they could find that the lawyer is completely incompetent, and then they would raise that, not only ask that he be removed, but involve, I think it's the same in Russia. Here you have to pass a bar exam, so his bar would be notified. If it's found that he's doing something against the defendant's best interest, so for perhaps working with the prosecution behind the defendant's back, giving the prosecution information about the defendant, all of these reasons would give the state or a court a right to remove the counsel that has been assigned to a client. If an individual who is not a citizen of the country is arrested, they have immediately to be informed of their right to speak to their counselor representative. So if, for example, a US citizen is arrested now for these protests, his consular officer under law, international law, would have to be informed and be able to have access to him and to speak to him. The consular officer has to arrange for the legal representation of the suspect or the accused. If the defendant appears before the judge and you are monitoring and he does not have a defense, if he does not have a defense lawyer, you should monitor whether the judge informs him at that point. If he's already gotten to the stage of being in court and he doesn't, whether the judge has informed him, because that duty then passes to the judge to let him know. As a monitor, the standard for a good legal defense is pretty low, and this is internationally. You don't have to be a defense lawyer. Under international standards, you don't have to be the best defense lawyer, but you have to be able to meet the basic requirements for a defense, and to represent that individual. And if you're monitoring a trial and you see crazy things, you see a defense lawyer who's, not making any objections, who's laughing with the prosecution, having lunch for the prosecution, these sort of things where you see in front of you that the lawyer is not acting or representing his client's best interest, that should raise a red flag, and you should note that immediately in terms of your assessment of whether a trial is fair or not. And this means looking to see, does the lawyer question witnesses? Does he question them properly? Does the lawyer advocate on behalf of the defendant to the best of their ability? So best of their ability, again, is a low standard, but you have to see some sort of action that's working to defend, working in the direction of defending a client. Did he appear to be qualified and come to court prepared? Was he in any way hindered? Was he intimidated or threatened by state authorities and told not to act on that individual's behalf? If you hear of that, That has to automatically be noted, because then he's clearly not going to be able, if he feels his own life or his family's life is at risk because he's defending somebody, that has to be noted. Um, I know, for example, in the United States, lawyers who defend terrorists, even though under the US law, every person has a right to a defense, and most people who are lawyers feel very strongly that every defendant has a right to the best defense they have. Um, those Many of those lawyers who were defending terrorists were threatened, and their families were threatened. But security measures were put in by the states. But if it is actually the office of, if it is actually the state or it is the prosecution office who's making those threats, that's a different story. That's extremely grave, and that needs to be monitored and reported automatically, as that is violating the right to have counsel and to have a proper defense. If a defendant wants to represent themselves, he has a right to. So if he's prohibited from that, that is also a violation of his right. And you would need, as a monitor, to see why that is happening. Perhaps they're disabled in some way, and the judge doesn't believe that they're mentally capable of defending themselves. Then that's something you should take account of and not see, again, as being a violation of his right. But if it's just some desire for them to have specific counsel assigned, then you have to watch that, and monitor and take note of that. Whether the defendant is paying or seeking a public defender is up to the client and his private finances. That's not a matter for the prosecution to make, or any sort of determination, or for the court. The European Court of Human Rights found that a defendant who retained his own lawyer and did not alert authorities to any representation issues could not expect authorities to intervene. So if the individual has taken a lawyer who he's not happy with, he cannot expect the court to notice and to get involved, and stop and replace that lawyer. It's his own choice. And it will be his choice to remove that lawyer if he's unhappy. The UN Human Rights Committee in death penalty cases, including where counsel withdrew an appeal without consultation with defendant, and where counsel conceded without the defendant's authorization that there was no grounds of appeal, where the counsel was absent during the hearing of a witness, or was absent during a judge's sentencing, or where counsel was only appointed on the first days of a trial, found this was all violations of the client's individual human right. And again, these are the indicators of whether, and these are the facts. So when this is translated for you, when it says indicators, whatever that's in Russian, that is where you should look if you're monitoring a trial. These are the elements that you should be examining to determine. So is the lawyer competent? Was he hindered from effectively representing the client? And were they, when they sought to defend themselves, were they allowed to? So right to translation and interpretation. And again, this is what I've mentioned to you, I saw violated in a US court, in a US federal court here in the Northeast, which is supposed to be, really bastion of rights. This individual's right was hindered by that. So the Article 14 of the International Covenant for Civil and Political Rights explicitly guarantees a right to an interpreter. So in certain cases, they may find, if it's, for example, in with whether this is fair or not, at the ICTY, the Yugoslav Tribunal and International Court, the amount of documentation was so enormous that translations were staggered. So um, the the translations of documents might arrive later than where it was necessary for what was being introduced in court. The ICTY found that this was okay because the defendant was eventually getting the full translations. They were all being translated into Bosnian Croat Serb. So this would happen after, sometimes in delays. So it can be a staggered process. In an ideal world, it is not. In an ideal world where he has an interpreter with him at all times and has documents translated before they are presented in court. The reasons obviously are you cannot defend yourself if you don't have interpretation and translation. And this means not just, if, for example, of somebody who's French is tried in Russia, they don't speak a word of Russian, their lawyer can maybe communicate a little bit in French, that those documents should still be in French, because he as a defendant has a right to examine the facts of his charges and the names of his witnesses and what those witnesses are saying. And again, from pre-trial through trial to sentencing. Is the interpreter, things that you should, indicators for you, is the interpreter or translator credentialized? So they have the credentials. I know, I'm sure in Russia, because I know in former Yugoslavia, it's a very big deal to be a translator, a certified translator. So that's the person who should be in court translating, not somebody who just happens to know the language. Is he impartial? We had this issue in here in the United States, where one of the translators was Liberian, and his family were victims. So the defense raised that and said they were concerned about the translator because his family had been victims of the person who was being tried. Is the defendant able to participate? So again, did he get his documents translated before so he can say, this is right, this is wrong? Does he have knowledge of the case against him? And is he able to exercise his right to defense? Those are the three things that need to be met. So as much as, if the ICTY found that whoever was being tried was able to meet those things, be able to participate, know his case, and exercise his right to defense, even though there was a staggered delivery of translated documents, then that's okay. But it has to, those three things are the critical elements that are reasons that it's required to have an interpreter. Oops, I misspelled that. The right to call and examine witnesses. So the International Covenant for Civil Political Rights says, in the determination of any criminal charge against him, everyone shall be entitled to the following minimum: to examine or have examined the witnesses against him, and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. The right to call and examine witnesses is a key element to a defendant's ability to mount an effective defense. Defendants must be allowed to present their own witnesses and to challenge the witnesses of the prosecution. A defendant must have the opportunity to examine them and produce evidence to counter what these witnesses are saying. Witnesses can include a victim of the crime, an eyewitness, somebody who can testify to other matters relevant to the case, such as an expert witness, including, for example, somebody who could, like an alibi to the time, again, an expert on ballistics, on munitions, on, forensics, anything, any single witness. The defense has to be able to challenge it by examining and calling witnesses, examining that witness's testimony and calling their own witnesses to counter that. The defendant must be afforded the same legal powers as the prosecution. including the power to compel the attendance of witnesses. It's important to ensure the defendant can mount an effective defense. So as much as a prosecutor can subpoena and call somebody and say you have to appear, and that person will feel nervous and of course will come to court because it's the state calling them, the defense should have that same right. The state should assist him in compelling a witness to appear in his defense that he's named. So if you're monitoring a trial, what are you looking at? You should record whether any side's attempts to call witness was rejected. And if those rejections were made, you need to find out what are the reasons for it. You should note whether any party's attempt to question a witness was restricted. Either by limiting the time available or by prohibiting certain lines of questioning, and if so, on what basis? Are there significant differences between the prosecution and defense calling witnesses, such as all the prosecution witnesses being called, but the defense's request being refused in large numbers? That's automatically an indicator that his right to call witnesses is being violated. Are those witnesses being threatened? What are the reasons that these witnesses are not coming to court and appearing? Whether the defendant was given less time to question the witnesses, whether the witnesses were present in the courtroom before they were questioned. This is a big deal in the United States. If you're going to be called for a witness, as a witness, you're not allowed to sit in the courtroom before watching the proceedings, because that can actually tamper and affect.
Hi, David. It's Andres. It's Andres Delnikov.
Hi. Thanks for calling.
Yeah, so.
For that.
Sorry, Victor. Do we want to take a 5-minute break, or should I keep going? It's about 11:15.
I'm sure if you feel like we need a break, we can do that. Otherwise, to have a little bit of time left depends on how much material you have left. Yes,
I have a lot left, but I can keep going. Let me keep going.
Okay,
if I have anything extra, I could also finish next week, because we have some extra next week.
Great, thank you.
So the other right, the right to be presumed innocent. This is a big deal in the United States. Very often when individuals are renowned and famous, they are, whatever they're alleged to have done is in the newspapers, and that can affect how individuals look at them. So if cannot, it's always part of, in the United States where you have juries, examination of the juries, asking how much they are aware of what this individual is charged with, and what is their impression of that individual. So if the newspapers have judged him to be a criminal and to be a bad guy, it will work against him getting a fair trial if all of the jurors have read this and seem to believe this. The International Covenant on Civil and Political Rights, again, this is what I'm going to be repeating, states, Article 14 states, everyone charged with a criminal offense shall have the right to be presumed innocent until proven guilty according to law. General Comment 32 of the UN Human Rights Committee states, the presumption of innocence, which is fundamental to the protection of human rights, imposes on the prosecution the burden of proving the charge, guarantees that no guilt can be presumed until the charge has been proven beyond reasonable doubt, and ensures that the accused has the benefit of doubt. The presumption of innocence applies to all defendants during all stages of criminal proceedings, including during pretrial investigations, trial proceedings, and on appeal. The right also continues to apply to a defendant who has been acquitted or against whom proceedings have been discontinued without a finding of guilt. So, for instance, if a decision acquitting the defendant should not include wording that casts doubt on their innocence. So the decision shouldn't say, yes, we're letting him go, but it's on a technicality, he's probably guilty. It should be framed always as he has been found innocent. So what are indicators of a violation of this right? public comments by judges, lawyers, government of defendant's guilt, defendants being held in cages, heavily armed guards. That is a big indicator. I think I saw, I watched the documentary on Pussy Riot. I think they came in and they very clearly were held away. It gives a visual impression of guilt. If you have somebody being held in a cage or having heavily armed guards and their hands cuffed, it visually, if you're having a judge or a jury, gives them an impression of this is a dangerous person. This is somebody who can't even be sitting next to their lawyer. They have to be caged. So that is bad. Judges that make statements that suggest that the defendant is guilty of the crimes charged before the verdict is reached. This happened recently in the United States. So the judge was talking about an individual and saying, well, you know, because they've committed this, and this. It's the judge has to, from the start till the end, even when they give their instructions to a jury in the US, has to seem and has to be impartial, but at a minimum has to give an appearance that they are impartial. They can't say things that make it sound like the defendant is guilty. Number 3 indicator is public authorities, such as government officials, prosecutors, or police, saying or doing anything to suggest that the defendant is guilty before the verdict is announced. This could include, for instance, shackling defendant in a cage or otherwise presenting defendants in a way that they indicate that they're criminal. It could also be prejudicial public comments to the press. So if the prosecutor is going out and saying he is the worst animal we've ever held, we're going to without at all saying this, you know, this defendant is going to be provided the trial, and from this we're going to determine that he is guilty, and we are going to prove our charges. That's all okay. But when you make extremely prejudicial comments as a state or government official, that hurts the defendant's right to be presumed innocent. The prosecution has the burden of proof throughout the trial. The prosecution is expected to produce evidence to back up its allegation, and that no one suggests the defendant has to prove themselves innocent. The prosecution has to meet the burden of proving each of the elements of the offense which the defendant has been charged beyond a reasonable doubt or to a very high standard. So when they go in, it is not the assumption that this guy is guilty. It's the assumption is that he's innocent, and now the prosecution will show exactly what law he violated and whether he violated it to the standard that's required to be charged and convicted with a crime. Pretrial detention must be the exception rather than the rule. You are not supposed to be held. You're supposed to be given bail and allowed to defend yourself freely. That is the standard. The bail, for example, if it's somebody who owns 10 private jets and can fly off anywhere, of course, the bail will be held very, very high if there's a risk of flight. But in normal cases, every federal case I've seen, the defendant has been allowed to accept, and I have not worked on terrorism cases, but in terrorism cases are one case that you would not allow pretrial. There was the Boston bomber cases, all these cases, they're not allowed to defend themselves by being free. But the standard has always that they're able to defend themselves from their home. The authorities may not make statements about the defendant or present the defendant in any way that makes them look guilty. And that means the police, the individuals in the prisons, they should be treating this individual in a way that he's arrested, he's going to trial, and then after that we'll determine whether he is guilty or not. The right to remain silent. Okay, this is an important right that affects other rights as well. So in the determination, International Covenant of Civil Political Rights says, in the determination of any criminal charge against him, everyone shall be entitled to the following minimum guarantees in full equality: not to be compelled to testify against himself or confess guilt. Principles and guidelines for a fair right to a fair trial and legal assistance. Any confession or other evidence obtained by any form of coercion or force may not be admitted as evidence or considered as probative of any fact at trial or in sentencing. So if you are beaten until you, you appear and you give a statement, you've clearly been beaten, that is an indicator to any trial monitor that something's going on, and that has to be noted that his right to remain silent has been violated. The right not to compel, you cannot be compelled to testify against yourself. And in absence of any direct or indirect physical coercion, psychological pressure, or any other sort of pressures or threats. They have to be allowed to not have those pressures put on them so that they have the choice, the human right to not testify against themselves. So the first one is right not to be, it has the right not to testify or confess guilt. Has the defendant confessed to a crime? Anytime there's a confession, it will be important to determine whether that confession was coerced. So if you are monitoring a trial and somebody's confession is introduced, the best thing is to find out from the defense lawyer and for the defense lawyer to investigate, or from the defendant, whether he was forced to give that confession. Are there any allegations that a confession by the defendant or the production of any evidence was the result of coercion of any kind, since a defendant cannot be forced to confess guilt? Both words and documentary evidence can be covered by these protections. So you can note how a judge and a prosecutor respond to any such allegations. Has the defendant, so if they ignore, if the defendant stands up and says, well, I had to say this because they said they would kill my family, if the judge just brushes it off and the prosecutor just ignores it, that's automatically something to note, because he's announced that there's been a violation of his right, and that the confession should not be considered at all in court. Has the defendant been compelled to submit bodily fluid or tissue to the authorities? That's also another thing. DNA samples, things like that. That is supposed to be only by the defendant has to give that right. He cannot just automatically have his things swabbed. So that's it will work against him if he doesn't give it. It will be, for example, if the judge is examining and sees that this guy refused to give his DNA, or he refused to have his hands. For example, if there's a shooting, there would be the powder from the guns on his hands. If he refused that, that will of course work, will be seen negatively, but he has that legal right. Whether the defendant retracts any previous statement or confession, that can give an impression and can be evidence that perhaps the earlier statement was coerced or not given freely. Has the judge informed the defendant at trial of the right not to be compelled to testify against him or herself? Has the judge drawn any inference of guilt from the fact that the defendant did not testify or chose not to answer specific questions? This is a tricky one, because it is always better if defendant can stand on a trial and give his own testimony, but if he chooses not to, it can be used. It can be used against him. It should not be used. Sorry, somebody coming in. It should not be used against him. But that bias is very difficult to remove, and of course, you will see juries who are making an inference of, oh, wait, why didn't he? Was he not able to stand and testify on his own behalf? Adverse inferences. So the general rule is that the courts may not draw inferences from a defendant's choice to remain silent during questioning. However, there's some limited contrary practice, as I mentioned. So you have to watch, if you're monitoring a trial, to see if any adverse inferences are drawn, and if so, from what. Again, retracting given statements, coming into court beaten up. I very simply, the whole case that we spoke about last time about Magnitsky, something like, having a trial of somebody who's been died in prison and then trying him. That's all blatant violations. Is she showing mental or emotional stress? Is he confused about the details of a confessed statement? If he's being questioned and he doesn't even know the details of what he's confessed to, that's also an indicator to you that it could have been coerced out of him. In the case of a confession, if there is evidence of a lengthy interrogation, presentation of false or inflated incriminating evidence, or misrepresentations made. If the defendant is young or exhibits a low cognitive level, disability or impairment, as I've said, if somebody is easily manipulative, easy to manipulate because of their mental awareness, their IQ, learning disability, that's all something to consider as not a fair, there could have been an unfair taking of a confession. Whenever there is a question as to the legality of the evidence being admitted, it's important to monitor the reaction of both the judge and the prosecutor. So this is something to keep in mind. If the police have clearly, you're believing, you're monitoring a defense trial, and you're seeing that the guy is clearly confused, and there's clear indication that the police or investigators got this evidence from him through coercion or physical violence. If the prosecution reacts and takes this into account and moves, or if the judge is watching and says, we can't be considering this confession as evidence of this individual, then you need to take note of that, because that's all indication that he is having a fair trial. If the prosecutor and the judge are taking part in guaranteeing the fairness of that trial, and exclusion of that evidence, that works against this being considered a violation of his right. What is coercion? Again, it's physical coercion, torture, cruel, inhumane, degrading treatment, psychological coercion. This can be threats of physical violence, again, physical threats of physical violence against a family member, prolonged incommunicado detention, meaning kept all by themselves for months, or sedating a defendant with alcohol or drugs. Trickery, when the defendant's right to silence and not to be compelled to incriminate themselves can also be comprised through subterfuge or trickery. For example, when a police informant listens to information from a defendant who has consistently invoked his right to silence. So he might use a law that doesn't exist and say, no, actually, that you don't have a right to silence because of this, this, and this. He could lie and trick the man and then get a confession, and that is illegal. Legal coercion. European Court of Human Rights held that defendants may not be requested to submit potentially self-incriminating information on pain of fine, prison sentence, or contempt of court, where there's been pending or anticipated criminal proceedings against them. When there's no pending or anticipated criminal proceeding, the court has suggested that whether there would be a violation turns on the specific circumstances of a case. So you cannot say, you are obligated to give a statement, or we're going to put you in jail, or we're going to fine you €1,000, or you'll be held in contempt of court if you don't testify. None of those things are legal. If it is, and in this case, it's perhaps a witness refuses to testify or somebody else refuses to testify, it would turn on the specific circumstances of the case, whether it's found that you can do a contempt of court or fine that individual. Incentives. It may also be considered coercion to incentivize giving up the right to silence and the right to not be compelled to incriminate oneself. For instance, if it would be a violation to promise life-saving medical care or liberation of a family member if the defendant cooperates or provides self-incriminating statements. On the other hand, merely urging defendants to testify or confess guilt or warning them of their right to silence may lead to negative consequences are not typically violations. So if you say you're going to get off a lot easier if you confess, you're going to get off a lot easier if you testify about this, that is not considered an incentive, but actually using something like, we won't call the doctor until you testify, we won't call the doctor, or we will imprison your family member unless you testify or give them. That's illegal, and that's a violation of his human right to remain silent. Plea agreements are not generally unlawful as long as there are adequate safeguards in place. So if you watch US movies, you'll know this very well. It's very often the prosecutor will come in and say, if he confesses to A, B, and C, we are willing to make an agreement that he only has to serve 5 years in jail. If he has allowed to counsel and the counsel reviews that is not limiting his right to a confession. He's making that choice to admit something in exchange for a lower sentence. Exclusionary right and the right to remain silent. Exclusionary rule prohibits the introduction at trial of evidence obtained in violation of the law, including international human rights. It serves to deter governmental misconduct in the gathering of evidence and is an act to check on the ability of prosecutors and governments to benefit from such misconduct. The exclusionary rule prohibits the introduction of evidence obtained by torture and any other illegal behavior, such as in the United States, very often wiretaps. So if you're taping somebody's conversations, their telephone, you're filming them, all of that, you have to have a court order and it has to be approved by the court. You can't just do this. So anything like that is automatically excluded from evidence. There are no exceptions to the rule that evidence obtained by torture cannot be admitted into evidence. Nothing, not one statement given by torture can be excluded. The rule's fundamental one that is meant to deter, to dissuade the state from obtaining evidence through impermissible methods. Again, I'm going to use the example of as a violation of this is the United States with their terrorism charges. It's known that confessions were taken through torture, and that is a violation of international law, international human rights. International Covenant of Civil Political Rights, Article 14. All persons shall be equal before the courts and tribunals in the determination of any criminal charge against them. Of their rights and obligations in a suit at law, everyone shall be entitled to a fair and public hearing by competent, independent, and impartial tribunal established by law. The press and the public may be excluded from all or part of a trial for reasons of morals, public order, or national security, or when the interests of the private lives of the parties so requires. So to the extent strictly necessary in the opinion of a court, where publicity would prejudice the interest of justice. But any judgment rendered in a criminal case or in a suit at law shall be made public, except where the interest of a child, a juvenile person, otherwise require, or proceedings concerning matrimonial disputes or guardianship of a child. So everybody has a right to have their court trial monitored and observed, and for the court to be competent, independent, and impartial. The UN Human Rights Committees clarified that the requirement of competence, independence, and impartiality of a tribunal is an absolute right. It's not subject to any exception. Competence requires that the judiciary decide matters before them on the basis of facts in accordance with the law, including international law. Consider what would happen if the government could simply tell a judge that a particular case, it's probably not hard for you to imagine, simply tell a judge that a particular case should be removed from his or her courtroom because the government prefers that another judge hears this case. Clearly, this would threaten the fairness of the trial. Competence also requires that the judges in a trial possess integrity and hold appropriate qualifications and training for judicial office. Independence has several dimensions. Judges should have some kind of job security or tenure. They should not be able to be fired at the whim of the government. This means that they're able to, they know that they have a job, that they're going to be paid, that they're going to be in this position for whatever length of time. They cannot be held threatened with removal or this or that if they make a judgment that's not popular. There should be a proper procedure for the appointment and dismissal of judges. Again, I'll use one instance that's in the United States questionable. Our federal judges are appointed indirectly through our president. So when Donald Trump was president, he appointed the U.S. attorneys all over the different states, and the U.S. attorneys were all members of his political party. And so when he's there, and the U.S. attorney, then he also appoints the federal judges. So the judges were all at that point had the same political views as Donald Trump. Now, this is the same thing is happening right now. All these prosecutors who were appointed by Donald Trump have been removed, and now Biden has appointed new U.S. attorneys in each of the different states and federal regions, and they are appointing their own staff. And the Democrats will now appoint their judges. So in the end, because of the U.S. system of continual changes between the political parties, it does usually come out to a balance, but it is part of whether you're going to say somebody's independent or not. Judge Barr, U.S. Attorney Barr recently stated that the hearings about whether these were fair evaluations of the electoral process, he stated that they were fair. The former U.S. attorney here in Pennsylvania, where I'm sitting, who's a Trump appointee, stated that Barr should have intervened, and they should have appointed a different judge to review whether the trials. So right as I'm stating this to you, and you're probably thinking Russia, right here, that statement by our former U.S. attorney is a full violation of the independence. If he had been allowed to pick a judge that would have been sympathetic to Trump, that would have been a violation of what I'm telling you is a human right. More generally, the judiciary as a whole should not be under the thumb of another branch of government. Judicial decisions must not be reviewable by other branches of the government, such as the executive. So our decisions, they go from, let's say in the federal system, they'll go all the way up through the highest courts and get to the Supreme Court. Same with the state, they'll always come to the top judicial branch, which is the Supreme Court of the United States. Many don't reach it because it's not a new fact that's being reviewed. So they'll go to the highest possible court. At no point will the president or a senator, they're not supposed to ever intervene and say, no, this person should be removed. And again, another breach by the U.S. government, there is the executive authority of pardon. So the president, when he's leaving office, has a right to pardon individuals. That is an exception to this rule, and is a violation of this rule because it doesn't, but whatever. As I said, the U.S. isn't the model. And these are, again, all ideals that the international community has put forward. Definition of impartiality: the judge should not be biased, for instance, because he or she believes the defendant is guilty before the evidence has been heard, or because the judge's personal convictions reveal hostility or ill will towards the defendant. And the same is true of a jury. They should be impartial. I think maybe somebody has seen in New York State, New York federal court, there's human trafficking, sexual abuse of minors case of Ghislaine Maxwell, who was working with this guy Epstein. Anyway, they whole trial went forward. She was found guilty. One of the jurors just came out and said he'd been a victim of sexual abuse as a child. That was a question on the jury form. And on the jury form, he said he had not been a victim. So it is very likely that case is going to be declared a mistrial, and it will have to be tried again due to the partiality and the background of one of the jurors. Biases: racial or status-based. A judge has made disparaging comments about individual's race, politics, nationality, origin, political bias. Again, if you have a very Trumpian judge who is having to review somebody who maybe was involved in some of the Black Lives Matter riots in the United States. Will that be, he should act as an impartial individual. He should not show, even if he has that political bias, it should not affect his decision. Subject matter bias. A judge has expressed views demonstrating a tendency to decide issues on a particular subject in a certain way. And that's something as a monitor to watch. If you see a judge constantly dismissing, for example, domestic violence cases against, violence against women, sexual violence cases, then you'll see that this judge has a bias and doesn't believe that men should be held responsible for these things. We have had that here in the U.S. where a judge, and this is last year, so this isn't 50 years ago, where the judge determined that took into account the length of the woman's skirt as a factor in her being raped. So this happens everywhere all the time, that there is bias, but it just has to be monitored and has to be an issue for appeal. It has to be an issue for you to be bringing up and either bring to the press or bring some notice to it. Party bias. A judge has a prior or existing relationship with one of the parties or witnesses to the proceedings that may make them favor someone. Judicial bias. This can be when the judge was previously a witness or a counsel or prosecutor involving the same defendant. That judge, it's a complete breach. He should not be he should not be acting as a judge in that trial. He should excuse himself. It could also be that he had prior involvement in the same case, perhaps on setting bail. That would not automatically be a bias, but it's possible that prior involvement in a judicial role could be a problem. So it's up to you to monitor and to see the facts. It's a subjective decision when it comes to issues like that on prior. So another indicator is spotting impartiality concerns requires assessing whether a judge has any actual personal prejudice or bias capable of affecting their decision making, or whether they will reasonably be perceived as having such prejudice or bias. However, impartiality will be assumed in a given case unless evidence to the contrary exists. If you have information that the judge has told you or somebody has told you that he will be fired for releasing somebody or finding them innocent, that's automatically to be noted. Evidence is to be gathered about that fact, and that's you either in the US system, you'd be pushing immediately for an appeal. And if it's not possible in the legal system, monitor it, note it, make it public. The reasons that you want to have a fair trial is to ensure proper administration of justice, and it's important for transparency. And everybody, including the victims, the press, are able to see it being done. Again, I think I cut off when I was mentioning this United States restriction of bringing phones and laptops into federal trials. This really does restrict an individual's ability to follow a trial or to take notes on the trial. So that's one thing to keep in mind. So indicators of a violation of this right. Has public notice of this hearing been given? So it should be public that a trial is going to happen in either the courtroom or posted well in advance of the trial. The public must be able to get in and to enter the courtroom. I've been in courtrooms where, for federal trials, for war crimes trials, where they limit the number of people. So, I mean, especially now with COVID, there's a limitation of number of people coming into courtrooms, but they might only say this courtroom seats 50 people, we're only going to allow 45 people in. And at those points in the United States, they always open a second room in the building. So, for example, journalists usually go into another room where the trial is being live broadcast if they can't get access. But there should be some way that they can follow and monitor a trial. Were all members of the press, public and press able to attend the hearings, or were particular groups prevented from entering the courtroom or asked to leave or removed from the courtroom. For example, if individuals are political supporters of the individual, are they being asked to leave so that people who are perhaps supportive of the defendant are unable to monitor and be involved in the watching the trial? That's all to be considered in whether it was a public trial. Were there any conditions imposed on entry? In the United States, for a federal court, you have to present an ID. You have to leave the ID downstairs for security, and you have to go through numerous detectors, metal detectors and things. So there are conditions imposed on entry, but it should never be based on who you are as an individual, your political party. If there's, again, this is what I mentioned, if there's not enough seating in the courtroom, there should be another room provided to observe the trial through a live feed on the monitor. The right to a public trial applies differently at different stages of the trial process. This is, I've never been involved where the pretrial things are, you can usually even go in the US to watch jury selection. But it is possible if it is something very sensitive. Oh, and there are times when there'll be a discussion between the prosecution, defense, and the judge that they will cut off all of the audio, microphones, anything. So the people sitting and watching the trial cannot hear what's being, it's called in the United States, it's called at the bar. So you're going to the judge to discuss. So that can be private. During the trial itself, are all or part of the public excluded from the courtroom in exceptional circumstances. So there might be, and this is completely not a human rights usually issue, but I know in the United Kingdom, when there are high-level divorces of celebrities, in the United Kingdom, there's a law which allows there to be no press to monitor because it can involve children and things, even though these are celebrities, they are protected by the court. So the next element we're going to look at is the right to be present at your own trial. I think I will go very quickly through this, and then I will stop at the next one. So the right to be present is very important in a trial because it allows the defendant to exercise a number of other fair trial rights, such as defending himself in person or examining witnesses. So if you're not allowed to even be at your own trial, for example, the trial of Magnitsky, where he's dead, so he obviously can't be, how can you state things? How can you state that something, that a confession was coerced or anything happened? How can you question witnesses? That's why trial in absentia is very, very, very rare and rarely allowed. The right to be tried in one's presence generally applies to all stages of the trial, including pretrial proceedings and appeals. But some pretrial and appeal hearings may take place in the defendant's absence. International Covenant Civil Political Rights, Article 14 says, in termination of any criminal charge against him, everyone shall be entitled to the following minimum guarantees and full equality: to be tried in his or her presence. What are indicators? Obviously, if you're watching the trial, you'll see whether the defendant is present or not. Did the trial proceed, and did the defendant have representation? Is the defendant able to participate by video link? Any parties, such as prosecution, may speak in absence of the other party to the court, but it has to be recorded. You really have to find a way that the defendant is aware of what is being said and is at least at a minimum getting daily transcripts delivered to him. Okay, I will stop now.